Hello, everybody. It's Christian Wagley here again with Healthy Gulf with some breaking news of interest to all of us that have been following the rate case and the huge rate increase for us FPL ratepayers here in Northwest Florida that hit back in January of 2022. So the Florida Supreme Court ruled today in a case challenging the rate increase that was approved by the Florida Public Service Commission back in 2021. And joining me to explain it all is one of the attorneys who challenged the case before the Florida Supreme Court, and that's Jordan Luebkemann, who's a senior associate attorney with Earthjustice, and he's based in Tallahassee. Jordan, thank you for coming on with us.
Thanks for having us, Christian.
You bet. So you challenged, along with others, the 2021 rate case by FPL on behalf of Floridians Against Increased Rates and a coalition of three other organizations. That's Florida Rising, the Environmental Confederation of Southwest Florida, and the League of United Latin American Citizens of Florida. You argued that the settlement was not in the public interest and that some parts of it violated state law. So this is incredible today that this case that you argued before the Supreme Court last February, I believe, and the court released their decision earlier today. What exactly did the court rule?
Yeah, so I think the last time that we got together and spoke, we mentioned there's a couple ways that it could go. The court could either reach the merits, in which we argued that the multiple parts of the settlement exceeded the commission's statutory authority, and that the settlement itself as a whole was not in the public interest. The court stopped short of that today, and instead they focused on the sufficiency of the order itself. So what this case was doing was actually, when we talk about challenging the settlement agreement, what we were challenging is the Florida Public Service Commission's approval of the settlement agreement. So that's the actual order that is being challenged. And the Public Service Commission, in approving a settlement, can't just thumbs up or thumbs down. It has to explain why the settlement, taken as a whole, is in the public interest. And that means defining the public interest. That means looking at all of the major elements of that settlement agreement and making factual findings as to those elements, and then coming up with some kind of global determination about whether this public interest standard has been met. And we argued from the outset that they failed to do so. It's our argument on the merits that they could not do so. On this record, you just can't show that this largest increase of rates in U.S. history was good for the public interest, because frankly, it wasn't. But what the court did today is it said, you have not, and this is a direct quote, you haven't given us anything to work with. That's what the majority opinion today said, is that we, the Supreme Court of Florida, cannot meaningfully review what the commission did, because the commission did not show its work. The commission did not show us what findings it was purporting to make. And so we can't make a determination about whether those findings are actually supported by the evidence or not.
So what happens next?
So next, we will go back to the Public Service Commission. Basically, the order sends this, the order from the Supreme Court today sends the commission's order back to the Public Service Commission with specific instructions on explaining how it is making these determinations. And so, and specifically, there's a few substantive areas that the court noted that it was particularly interested in seeing the commission show its work, such as the Solar Together faux community solar program that we talked about last time. So it will now go to the commission, and then the parties will confer with commission staff, and we'll sort of get together to figure out what the way forward is. But the next step of the proceedings will be back at the Public Service Commission.
Would we expect that it would follow a similar process to when a rate case starts from scratch? I mean, I know this one's already, the case has already been made. All the supporting documentation had been provided by Florida Power and Light. Do you have any sense of how that process is going to go?
Yeah, so the Supreme Court's order today specifically mentioned that it was sort of up to the discretion of the commission whether they wanted to reopen the record or not to allow for more evidence to be put in, or whether they simply wanted to go back through the existing record and just try to better account for the decision that they made. That last time this happened a year ago, when the Duke Clean Energy Connection Program, which is Duke's version of Solar Together, that order was also sent back to the Public Service Commission for failing to show its work. And in that case, the parties, sort of all the parties to that challenge agreed that the answers were already in the record and there was no need to open it up again and add more to the record. So there was supplemental briefing in which the various parties went back through the record to rebolster their arguments with what was there, but there was no additional testimony, no additional witnesses, no additional discovery. So that's one possibility that could happen here. It could also be possible, just given the magnitude of this rate case, given how much time has passed, that the parties might ultimately decide to seek reopening the record. But I couldn't say at this point how that's going to go.
So regardless of whichever of those possible paths forward is chosen, do you know if the public's going to have an ability to be involved in this? I mean, normally, obviously, in a rate case, there is the opportunity for public comment online. There's the opportunity for the public to attend meetings of the Public Service Commission and speak in person. Do you have any sense of whether the public's going to be able to be involved in this process at all?
Yeah, so to that I would say this is the Public Service Commission. This docket with the FPL rate case remains open, pending the challenge of that decision in that docket. And so you can go there to the docket and add comments. You can call the commission. You can demand that the commission hold customer service hearings. They're not required to, but it doesn't hurt for them to hear from the ratepayers, because as we've talked about before, if they don't hear from you, they don't know what you might be going through. They hear from the utilities, which always tell them that everything is great for their customers and they're receiving world-class service for unbelievably low prices. And if that is not your experience, I urge you to let the commission know.
We'll be sure to get that that link to that public comment space on the PSC website out to everybody who's interested in this, and they can start getting those comments in now to make sure that the public voice is heard as this process gets, I guess, reconsidered in some form or another. So, anything else that we should know about this?
Yeah, before we go, I would really want to add that this is a really important decision from the Florida Supreme Court, in that it is demarcating a new era, where in the past there's a lot of precedent at the Florida Supreme Court basically putting on kid gloves when it comes to the Public Service Commission. It's long been held that the Supreme Court will not disturb findings of the commission unless it's just so egregious, and it was very, very deferential. Much more recently, there was actually a constitutional amendment in Florida which removes deference when the Supreme Court is reviewing, when any court is reviewing the action of an agency, a state agency. There's no deference on any findings of law. All of that is reviewed what's called de novo, or all over again, by that court. And prior to this case, there hadn't really been a test of what that new constitutional amendment would mean for deference to the Public Service Commission. And today, the Florida Supreme Court announced very loudly and very clearly that the era of rubber stamping anything that comes before the commission is over, and that the commission must show its work. It must make findings of fact and law such that when a decision of the commission is challenged in court, the reviewing court can actually figure out what happened. And so even without reaching the merits of this case yet, this is a victory for all Floridians, because requiring the Public Service Commission to more clearly explain the choices that it's making can only have good effects for Floridians.
Well, that does sound like very good news for Floridians, because I know people who have tried to follow the Public Service Commission, lay folks like myself who aren't experts in it like you. We struggle with it. We struggle to be involved in it because it's so bureaucratic. It's not easy for people to understand it. And I think there always kind of has been that feeling that once they've ruled on something, there's not much recourse. And even during the process, it seems just kind of cumbersome and difficult and bureaucratic and tough for the average citizen to feel like they're involved in it and to weigh in. So that's very good news. Obviously, our system depends on checks and balances, and so that no one agency or branch of government is all powerful, and that they can check on each other. And so in this case, the judicial branch was able to provide that. It sounds like a departure from anything in the past. So that's certainly very good news for Floridians. So, Jordan, thank you again for taking the time to explain that to us. Jordan Luebkemann is a senior associate attorney with Earthjustice, who, along with his colleague at Earthjustice, Bradley Marshall, argued this case before the Florida Supreme Court on behalf of these organizations in particular, but also you could say on behalf of all of us who are ratepayers, millions of us who are ratepayers to Florida Power and Light. So thanks again, Jordan. We greatly appreciate it.
Thanks, Christian.